Hello and welcome to our video. My name is John Watts. I'm a consumer protection lawyer in Alabama. And I want to talk to you in this video about why are you getting a motion for summary judgment in the debt collection lawsuit that's been filed against you. So you've got Midland Funding suing you, or Portfolio Recovery, or Calvary, or Cash, or whoever it might be. They're suing you and you're representing yourself. Okay, I mean, if you have a lawyer, then talk to your lawyer. But if you're representing yourself, you file an answer. And then at some point, you get this big package in the mail and you look at it and it says, Plaintiff's motion for summary judgment. Like, what in the world is that? Well, that is a technique or a strategy that the rules allow, not in small claims court and usually not in district court, but in what we call circuit court in Alabama. And that's going to be anything that's definitely anything over $10,000, and it can be anything over $6,000. And this is a request of the judge to enter judgment against you. And so a motion is just a request for the court to do something, and summary judgment is the plaintiff, the debt collector, saying, look, judge, we don't need a trial. There's no sense taking all that time. Here are all the facts. Here's all the evidence. Here's the law. There's no way we lose. We win. The only reasonable explanation or conclusion is that we win. And so just summarily enter judgment. Now, a couple things about this. This is typically done, it's always done, I should say, under Rule 56 of the Alabama Rules of Civil Procedure. It's not always identified specifically by the collection lawyers, but that's the rule of civil procedure we're looking at, is Rule 56. And there's oftentimes among consumers who are representing themselves this idea of, well, I don't like that. I don't agree to the summary judgment stuff. I want my day in trial. I will show up at court and I'm going to argue my case. And I'm going to bring my witnesses. Well, the problem is if summary judgment's granted, it's over. Case is over. There's a judgment against you. Just like it could be a default judgment. Just like it could be a judgment after a trial. A summary judgment, same thing. It's a judgment. And so it'll be set for a hearing. And let's say it's set on, trust me, I can't remember like what's a Monday or a Saturday, so forget about that. But let's just use this date. It's set on March the 20th. Well, normally you've got to file your response by March the 18th, sometimes March the 17th, and depending on which court you're in. And what happens if you don't do that? Well, then you show up on the 20th and the judge says, hey, you didn't file anything by the deadline, you lose. And you go, but wait, I got all this paper here and I brought in witnesses. And the judge goes, whoa, no, you missed the deadline. I'm not going to consider any of that. So all I have to consider is what the other side sent, and here are all the facts, and they have affidavits and all this stuff, and I'm going to rule against you. People go, but that's not fair. And I completely get it. It's very difficult to do this on your own, particularly when there's a summary judgment. But if you are doing it on your own, you have to understand those rules. Because if you don't understand the rules, it'd be like this, playing football, and somebody lines up to do a punt, and instead of doing a punt, they throw a touchdown pass. And imagine the other team and the coach go, no, that's unfair. You were supposed to punt the ball. They're like, well, we did a fake punt. I didn't know you could do that. Well, you got to know the rules. If you're going to play the game, you have to know the rules. And this Rule 56 is something very, very important if you're facing this. So you've got to know when to respond. You have to know how to respond to this. And so I can't tell you in this video all the details of how to respond and what evidence to use, because it's going to vary based on case-by-case basis. But I just want you to understand what it is. This is an attempt to get your case over in a bad way, okay? It's an attempt to get a judgment against you so they can start garnishing your paychecks, garnishing your bank account, putting a lien on your house, even selling your house. So it's very, very serious. You've got to take it seriously. I see so many people that just go, I think that's a scam. I don't believe, no judge would ever do that. Yeah, the judges have to follow the rules, and you don't follow the rules, they're going to follow them and rule against you in a summary judgment. So take it very, very seriously. Educate yourself on what to do if you're handling this on your own. Obviously, if you have a lawyer, get your lawyer to handle this. But I just wanted you to be aware of what this is and the danger that it poses to you. So if we can help you in any way, unless you're represented by a lawyer, if you've got your own lawyer, talk to your own lawyer. Don't call us. We can't talk to you. But if you don't have a lawyer and you have questions about this, we'll be glad to spend a little bit of time with you and give you some thoughts and advice if you're in Alabama. 205-879-2447 or alabamaconsumer.com. Thanks a lot and talk to you soon. Bye-bye.